Hi everyone, I am Maya from TMC for Seniors, and today I have Shanelle Schmitz here with Zack Schmitz. She is an attorney for elder law, and today we are going to be talking about understanding wills and powers of attorney. I do want to let you know a little bit about Shanelle's background. So she's got a focus on estate planning and elder law, and she represents clients in probate court in contested trust administration matters, guardianships, conservatorships. And I know she's going to be able to share quite a bit of information today about wills and powers of attorney. So welcome, Shanelle.
Thank you, Maya. It's great to see you. And hi, everyone. I wish I could see you in person. So we'll go ahead and get started. As Maya was saying, I'm an attorney here in Tucson, and I'm a partner at the law firm of Zack Schmitz, PLC. So if you can go to the next slide, it'll have my contact information. And I just want to invite anyone to reach out to me with any questions if we don't get to them during the presentation. I'm happy to answer any questions about the presentation today. And so the next slide is a legal disclaimer. So as an attorney, of course, attorneys always like legal disclaimers. So this is just to go over the fact that the legal information presented in this PowerPoint presentation should not be construed to be formal legal advice, nor the formation of an attorney-client relationship. So if any results are set forth within the presentation, those results are based upon the facts of that particular case and do not represent a promise or guarantee. So it's important for you to contact an attorney for a consultation on your particular legal matter, and they can give you specific advice regarding your specific legal case. So the topics that I'm going to go over today are: what is a will? Common misunderstandings regarding wills, important power of attorney documents. So those are the durable financial power of attorney and the healthcare power of attorney, and other important documents, including a living will and a HIPAA authorization. Next slide, please. So the first question is, what is a will? So a will is written instructions to the court as to how you want your estate to be handled. And in your will, you can name a personal representative, which is otherwise known as an executor in other states, and they will be responsible for administering your estate. You also designate the distribution of your property, so you would be stating where you want your assets to go upon your death. And you can also create testamentary trusts within your will. And you can include, you can incorporate a memorandum of personal property. So that could be a handwritten memorandum where you can state where you want certain items of tangible personal property to go. So for instance, if you had a family heirloom ring and you wanted it to go to your granddaughter, you can list that in your memorandum of personal property. And it's easier to change once it's in that versus having to redo your will if you decide you no longer want to leave it to your granddaughter. You can be very specific about personal property. You can even specify where you want to leave items like your living room couch, for instance, if you want it to get that specific. You can also name guardians for minor children. And it's very important, if you have any minor children in your custody, that you have a will in place so that you can name a guardian for who would be responsible for taking care of your minor child if something were to happen to you. And you can also direct the payment of debts and taxes in your will. Next slide, please. So in Arizona, you can have either a typed or a handwritten will. The typed will has to be signed by the testator, and it has to be signed in front of two witnesses. So the witnesses shouldn't be receiving anything in your will, and they also should not be related to you by blood, marriage, or adoption. And there is a question in Arizona as to whether it actually has to be notarized, but it's probably best practice to go ahead and have it signed in front of a notary as well. There's with the handwritten will, there's not all of those requirements. So the handwritten will only has to be in the testator's handwriting, and it has to be signed by the testator. And just to clarify, testator is just a fancy way of saying the person who is creating the will. Next slide. So in Arizona, the testator must also have what's called testamentary capacity. So the testator must know the nature and extent of his or her property. So they must know what their assets are. So if they have any real property, where is that real property located? If they have any, say, investment accounts, life insurance policies, bank accounts, any of that information they would need to know. So essentially they need to know what their property is. The next test is whether or not they know the natural objects of their bounty. So that means, do they have any children? If they do have children, who are their children? What are their names? What are their ages? Do they have grandchildren? Those are the types of questions that you would be looking at to see if they know the natural objects of his or her bounty. The next part of the test is whether they understand that they're engaging in a testamentary act. So do they understand that if they're drafting a will, that they're stating where they want their assets to go to upon their death? So that's the guidelines for determining if someone has testamentary capacity to go ahead and create a will in Arizona. For out-of-state wills, so out-of-state wills can be valid in Arizona if the will meets the original state's requirements for being valid. So for instance, if you were living in, say, Colorado, and you drafted a will in Colorado, you had to execute it, and it was valid under Colorado law, and you came to Arizona, then, and say you died in Arizona and your estate was being probated through Arizona court, then the test would be whether or not that will was valid under Colorado law. And if it was, then it would be valid in Arizona. But it is probably a good idea if you do have documents that were prepared out of state, to have an estate planning attorney here in Arizona take a look at your documents to see if there's any needed changes or if you should do a will here in Arizona. Next slide, please. So these are some common misunderstandings regarding wills. So the first common misunderstanding is that a will is designed for probate. So a will is instructions for the court. So it's designed to actually go through probate court. And it's also only effective upon your death. So it has no effect while you're alive. Therefore, it doesn't have any kind of disability provisions. So it wouldn't have any effect if, say, for instance, you became incapacitated, you maybe got Alzheimer's or dementia during your life, and you were no longer able to manage your assets, your will wouldn't have any effect. That wouldn't provide any kind of provisions for someone to step in and manage your affairs. Another common misunderstanding is the personal representative, otherwise known as executor, has no authority until they're actually appointed by the court to be your personal representative. So a common misunderstanding, and I actually received a call last week on this, is the personal representative wouldn't be able to engage any business on behalf of the estate without actually being appointed by the court. So they couldn't, say for instance, sign a loan or sell a piece of property if that property is going through the estate without actually having that court appointment. And anyone over the age of 18, oops, if you can just go back one, sorry about that. So anyone over the age of 18 needs a will, not just those with significant assets. So a lot of times people will tell me, oh, I don't need a will because I don't have significant assets. And that's not correct. And everyone has different ideas of what significant assets mean. And another thing is, no one knows what type of assets they'll have at their death. Sometimes people will, the cause of their death will actually create a windfall for their estate. Say, for instance, they were involved in a car accident and it was the other person's fault. Maybe there's going to be a windfall going into the estate. So it's important to have a will in place to go ahead and tell the court how you want your assets to be distributed. Because if you don't have a will in place, then the Arizona statutes will decide for you. Next slide. So the next important document is a durable financial power of attorney. So this is a document that is effective during life, and it's only effective while you're alive. It has no effect after you die. And so it does have disability protection because you could name who you want to be in charge of your assets if something were to happen to you. There are two different types. There's a springing versus immediate. And springing just means that the powers spring into effect upon the event of something happening. Usually it means that if you're incapacitated, usually what I see in documents is that if you're incapacitated, you would state that there has to be some kind of showing of incapacity, whether it be a signed letter from one or two physicians saying that you're no longer able to manage your assets to go ahead and have any effect. The other type is to have it be effective immediate. So that means it's immediately effective upon your signing. So if you signed it today, whoever you have in place as your agent would be able to go, say for instance, go to the bank and manage your bank account if needed. So usually when we're drafting financial powers of attorney, we're making it very broad. That way the agent can basically step into your shoes and do whatever they need to do to manage your affairs. So some of the powers that we might include in your power of attorney would be the power to file taxes on your behalf, the power to apply for government benefits or collect your mail, or maybe even care for your pets. Those are some common examples of some of the powers that we would include. And of course, it's a great responsibility and liability for your agent. So it's very, very important for you to appoint someone who you trust to serve as your agent. And sometimes there's a common problem where people don't really have family or friends that they may trust. So there are other alternatives, such as a licensed fiduciary or a trust company who may be willing to serve as your power of attorney. So there may be options for you. One common problem that we see with financial power of attorney documents is they're not always accepted. So sometimes banks won't accept them if they're over a certain amount of time, or if they're older than, say, 2 years or 3 years. In that example, you may need a conservator, and a conservator is appointed through the court to manage your affairs. So it's important in your financial power of attorney to actually nominate a conservator. That way you're letting the court know who you want to serve if for some reason a conservatorship were ever needed. And it's also important just to make sure that you are reviewing your documents pretty often. We generally recommend every 2 to 3 years to our clients, and usually we're recommending to go ahead and do a new financial power of attorney every 2 to 3 years. Next slide. So the next important document to have in place is a healthcare power of attorney. So in your healthcare power of attorney, you would nominate a healthcare agent, and that would be who you would want to make healthcare decisions if you weren't able to do so yourself. In your healthcare power of attorney, you can also nominate a guardian, and by doing a power of attorney document, the idea is that a guardianship wouldn't be necessary. But sometimes we do see instances where a guardianship is still required, even if you have the document in place. So that's why it's important to nominate who you would want the court to appoint as your guardian, if that were to happen. And you can also include funeral and disposition arrangement authority within your healthcare power of attorney. So you can state whether or not you want your agent to have the ability to consent to an autopsy, for instance. You can also provide your agent authority to make organ donations on your behalf, or you can state that you don't want them to have that authority. You can also specify whether or not you want to be cremated or buried. Next slide, please. So another important document is a living will, and sometimes the living will is combined with the healthcare power of attorney, or it's a separate document. And living will, just living means you're alive, so it applies while you're alive, and it's instructions regarding the level of care that you want. And it usually deals with extraordinary measures. So say, for instance, you were terminal, in an irreversible coma or a persistent vegetative state. In your living will, you can specify whether or not you want life-sustaining treatment beyond comfort care that would only prolong your death. And you can also provide a pregnancy override. So you can state whether or not you would want the living will to apply, even if you were pregnant. So the living will should not be confused with an orange form or a do not resuscitate or DNR form. I do get a lot of questions about this, and there is a lot of confusion. So the orange form, typically that's, you may have heard that someone says they have an orange form and it's posted on their refrigerator. So this type of form it only applies to first responders, emergency room personnel, or direct care workers if hospice is ordered. So it wouldn't apply if, say, you were admitted into the hospital, and it does not include withholding IV fluids, oxygen, or other therapies. So it's very different from a living will, and you really shouldn't need a do not resuscitate form unless you are terminal, and that's something that you really should be discussing with your physician and your attorney as well. Next slide, please. So the next document is a HIPAA authorization, and that's to allow the release of medical information to whoever you have listed on this form. And this power may also be included in your powers of attorney documents. Sometimes it is a good idea to have it separate, though, so that you can list different agents on your HIPAA authorization versus who you have on your agents on your power of attorney form. Because remember, on the power of attorney forms, those are who would make certain decisions on your behalf, whereas the HIPAA form, you can have it so that they just get that medical information. They don't have the power to make any decisions on your behalf. And so now I can go ahead and open it up to questions, if anyone has any questions.
Thank you so much, Shanelle. I'm actually going to leave your slide up for just a minute, just so that they have your contact information. I do have a question here about how often you should consider updating your will.
So generally we recommend meeting with an attorney, and this is what we recommend to our clients, is to come in every 2 to 3 years so that we can go over your documents, because there are life changes that you will want to, like certain life changes that you will want to make sure that you update your will after they occur, such as if you got married or divorced, if someone dies in your family, or maybe someone was born, maybe you have a new grandchild that you want to add into your will. So it's just really a good idea to review it and think about your estate planning documents maybe every 2 to 3 years.
Okay. And is there anything, I just had another one. Oh, they want me to show the living will slide again. Okay, hold on just a minute here, and let me go back to the living will slide. I'm thinking there might be a question coming with that, maybe regarding the orange form or, one other question that just came in, do wills have to be notarized? And I think you sort of answered that, but maybe let's repeat that. And also, is a handwritten will valid? So
if we could go back to this slide.
Of course.
Let's see, it's what is a will? The will and codicil requirements in Arizona.
Oh, hold on, sorry. No, that's the wrong one, right?
Yeah, I think it's one more back.
There we go.
There we go. So if it's a typed will, there is a question in Arizona as to whether or not notarization is required. It's probably best practice to have it notarized. If it's a handwritten will, then all that means is it has to be in your handwriting and signed by the testator. So there's no requirement that it be witnessed or notarized if it's handwritten. And yes, a handwritten will can be valid if it's in the person's own handwriting and signed by them.
Is there anything with videos these days as far as anyone leaving any kind of wishes through a video?
There is a new law in Arizona allowing for electronic wills. It's very complicated. I don't know any attorneys who are actually going by that statute as of right now.
Okay.
I think there's a lot of issues that need to be sorted out.
Okay. I have another question that just came in. If you are designated as a conservator in your financial power of attorneys, do you still have to review it every 3 years?
So, if you're designated a conservator, so you would designate someone else as your conservator in your power of attorney form. And that would just be who you would want to serve as a conservator if for some reason your financial power of attorney form failed and a conservatorship had to be set up. So yes, it still is a good idea to have your financial power of attorney reviewed every 2 to 3 years, and probably to update it within that time frame as well, so that hopefully you could avoid the need for a conservatorship through the court.
Okay. And I've got some other questions that have come in asking about cost. Is it really costly to prepare these documents?
It just depends. If cost is a concern, there are certain nonprofits here in Tucson that you can contact. Like Step Up to Justice is one of them, and they actually they're just rolling out a will clinic via Zoom. So that's something to look into if costs are a concern. And it just depends on each attorney has different fees and costs. You can feel free to reach out to us. We can go over costs, or like I said, there are nonprofits here in Tucson. There are other attorneys who may have different types of fee structures as well.
Okay. And can an executor live in another state?
Yes. And we also do probate administration at our firm, and we deal a lot with out-of-state executors. So there are ways to help, and it is possible to live in another state and execute the will here in Arizona.
Okay. And I've got one more question here, and it says in Arizona, as a community property state, does everything go to the spouse regardless of what a will says?
No. And there are a lot of different ways to leave property to your spouse or to other people besides just through a will that we didn't really go over today. So if you're wanting to make sure that everything does go to your spouse, it's probably a good idea to speak with an attorney and have them review the different types of assets you have to see if so sometimes assets you can like on a deed, for instance, you can have certain kind of deeds that transfer ownership directly to the spouse upon your passing without that piece of real property having to go through probate and go through your will. So it's not always just because it's a community property state, it doesn't mean that all of the property will go to your spouse upon your passing.
Okay. And I actually just got another question in. Everybody's got a lot of questions about this topic. We know it's an important topic. What happens if you die without a will? And what happens if you are married and you die without a will? So I guess let's maybe break that down into two.
Okay, so in Arizona, there's intestacy statutes that would apply. So if you don't have a will in place, then the courts would look to the statute. And if you're married, then your spouse would get everything that goes through the estate through the intestacy statute. If you don't have a spouse, then you're looking at if you have descendants, if you have children, and there's just a certain order under the Arizona law as to where your assets go.
Okay, great. I think you have answered all of the questions that we got today. That was wonderful. I do want to show your contact information again, Shanelle, just in case if anybody is interested. So they have your phone number. It was 520-664-3420. especially if they have any follow-up questions that you might be able to answer for them. And I really appreciate you being here with us today. I know you are coming back again in November, right? So we have you scheduled, and on the next talk, you are, let's see, I'm just looking, I'm sorry, I didn't have the date out here. We're talking about trusts. So the next talk is a trust right for you, and that will be on Friday, November 13th at 10 a.m. For anyone who would like to join us for that. But thank you so much for being here today, Shanelle. We really appreciate it.
Thank you, Maya. It's great to see you. Thank you, everyone.